This is Steven Leskin, and you have found your way to Oregon Divorce School. I am an attorney in Portland. I've been practicing law here for almost 30 years. I do these webinars twice a month. I cover a topic in depth that pertains to people who are going through divorce, in the hopes that understanding will make the process easier and more smooth. Tonight's agenda, we are talking about how a case moves through the Oregon courts. Um, in law school, this would be called civil procedure. Here we just call it long, arduous, and stressful. So, just by way of introduction, I don't take questions during the seminar, but I invite people to call me tomorrow or to shoot me an email if you have a question or you want to discuss your case. I'm always happy to hear from people who have said that they watched a seminar. If you're catching this online later, if you found it on the website, same thing. I'm still happy to hear from you. And these really are not intended as an infomercial. I'm not going to talk about myself. I'm not going to talk about my practice, maybe a little bit just to illustrate a point every now and then. But the point is to spend about an hour talking about a particular legal topic as it pertains to divorce. So the agenda tonight is to talk about how a case moves through the courts, and there's two ways that that happens. One is events within litigation and court deadlines. We'll talk about what basic pleadings are and how they help the case move forward. We will give an overview of the pathway through the court, and then this would not be complete unless we talked about what happens after the judgment is signed. Just because the case is over and the court has signed the judgment and a couple is divorced or custody is awarded, doesn't mean that you're never going back to court, as many people find out. So again, my name is Steven Leskin. I've been practicing law in Portland for a long time, since 1992, mostly in the Portland area all that time. I do mediation, arbitration, and litigation, and I do have webinars on each of those in depth. You can find me at my website, leskinlaw.com. You can contact me through email at stevenleskin@leskinlaw.com. And of course, the phone number, you're free to give me a call. And yeah, that's what I look like. All right, so what propels a case through the courts? And um, a case, generally, what moves the case forward and why it just doesn't linger in nowhere land is two things. One is court-imposed deadlines that begin once the case is filed in the court, and the document that starts the case moving is called a petition. It could also be, in divorce land, it's called a petition. In other assets of law, it could be called a complaint. It's called a petition because you're asking the court for something. You are pleading with the court for something. You are sending the court a message through a pleading. This is what I want, and this is what I'm asking for. This is the type of relief that I'm asking for. A complaint is always you can have criminal complaints and civil complaints, and a civil complaint is a case against somebody else, right? You're asking somebody else for something. You're complaining against them. A civil complaint is the same thing. You're asking the court to punish the state. The party of the state is asking for the court to punish somebody, so it's a complaint. Um, in divorce world, which we are just completely focused on here, uh, the case is driven forward by court-imposed deadlines. So, for example, after the petition is filed, you have 91 days to get a response filed, right? So, and that when that starts is kind of up to the court. Like it may not start like the day the case is filed. It may start when the court realizes that they have to send out a 91-day notice. But that means that the other side has to either file an appearance, or the person who filed the petition, the petitioner, has to take a default. So once you get a 91 days notice, there's only two options. Somebody files an appearance, the other side files an appearance, or is defaulted, or the case is just automatically dismissed by the court. Courts also have their own internal deadlines. For example, in Multnomah County, cases are supposed to get tried at about 9 months. And so the judges will try to get their cases out at about the 9 month mark. That's not set in stone, but it's strongly aspirational. Cases can go for a year and a half longer, but generally they try to get them out after a year. So those are two examples of deadlines propelling a case forward. Um, Cases are also propelled forward by motions, and a motion is a petition to the court or request from the court to do something. Some common petition, some common, I spoke, some common motions in divorce court are a motion for interim relief. Like, so if it's going to take 9 months for the court to hear a case, somebody may need interim spousal support or interim child support or exclusive use of the home if there's been domestic violence, something along those lines. Other types of motions, when I wrote down here was motion to appoint a psychologist for a child or an evaluator, to actually be an evaluator for a child, to do a custody child review for the court to help with the determination of custody. Other motions could be if you're not getting discovery, right? Both parties are obligated to exchange information about the marriage. If you're not getting the discovery you want, you can go to court and file a motion to compel discovery. And if the other side doesn't comply with the order to compel discovery, then you can file a sanctions motion. Other common motions would be common motion for a set-over for a trial date, motion to keep the status quo in place. Um, I don't know. There's lots of motions. Um, um, those are the big ones, though. But the motions also help move the case forward. Pleadings. Pleadings are the papers that are filed with the court. So um, uh, they pleadings communicate with the court. They tell the court that one of the litigants, one of the parties, want something, and usually it's going to be in the form of a motion. I want temporary spouse support. I want temporary um, custody of the kids until the court can make a final decision. Those are all pleadings. A pleading is um, any document that's written on pleading paper, and you know pleading paper as the lined paper with the two line. I misspoke. The numbered paper with the two lines running down the left side. That's pleading paper, and all of that is all of that, whether it's a motion, a request for discovery, or a motion for discovery to compel discovery. All of those are considered pleadings. Um, there are the two most important documents, the three most important documents in any divorce case are the petition, which initiates the lawsuit, the divorce, the response to that petition, and then ultimately it ends with a judgment. And uh, the petition sets out what the petitioner wants. The petitioner could be mom or dad, and um, it says that I, dad, want custody of the child. I want the house to be, I want to keep the house, or the house to be split in an equitable manner, or I want spousal support, or I want my attorney fees paid. So you're petitioning the court for all of those things. Um, the response to that tells what the respondent, the other side's the other party wants. So, for example, um, I just said that the petitioner says that um, husband should get the house. The respondent could come back and say, "I have no problem with that. We agree that husband should have the house, subject to X, Y, and Z," and that puts the that takes the issue out of it, makes it a non-issue, right? So the pleadings define the issues. And so the response, if you agree to an issue in the response, then it's considered agreed. It's considered admitted. And there's no reason to go to court to bring in evidence to prove that particular issue in the case. So you go through the divorce, you go through discovery, you go through a negotiation phase before you get to trial. You still can't get the case resolved. It goes before a judge, and the judge issues a judgment. And the judgment is the final is considered the final disposition of the case. And the judgment is composed of several parts. There's findings of facts, which are used later to establish benchmarks, particularly if there's spousal support or child support. And so the findings of facts are these are the facts as they are known to the court at this time. The orders come after the finding of facts and rest on the findings of facts. So, for example, in a spousal support case, um, the findings of fact may say that um, husband is this age, my wife is that age, husband makes this much, wife makes that much, wife has this education, husband has this education, wife has this job training, husband has that job training, and the court finds that spouse support is appropriate, and the order will say uh, um, spouse support is ordered for this long and in this amount based on, and what's not said is that, but that's based on the findings of facts, right? So it's separated between the facts and what the orders are. The third part of a judgment is what's called the money award. And the money award has an interesting power because the money award authorizes parties to engage in collection practices. So with the money award is the basis for example, garnishing somebody's bank account or garnishing somebody's paycheck every month. And so uh, that is based on what's in the money award at the end. So those are the component parts of a judgment, and that judgment is what uh, finalizes the court's ruling. There's two other types of judgments. One would be stipulated, where the parties agree and they come together and they sign it, and it has the same validity, and then it ultimately gets signed by the judge, and that has the same validity as a case that was that went before a judge and was tried. And then there may be a default judgment where somebody doesn't, where the respondent doesn't show up and loses by default, and the um, petitioner gets everything that was requested in the petition. Um, and as I talked about just right at the beginning of this slide, the pleading gets its name from the numbers and double lines on the pleading paper. Um, but it is called a pleading because you are pleading for something, not pleading in the sense of begging, but pleading in the sense that, like, I put it on this paper, right? I'm alleging that I have the right to these things, and I'm asking the court to award this relief to me. All right, pathways through the courts. So, just for conceptualizing, I'm breaking a lawsuit, a typical lawsuit, down into four stages. Uh, and these exist. This is certainly something that exists. But lawyers would never say we are in the pleading stage or we're in the discovery stage. You could be still in the pleading stage and doing discovery. You could be in the negotiation stage and getting set for trial. So these are not like found in any book or in any law, but it's just a way to think about like the parts of a lawsuit um, over time, and that's why it's called a stage. So the pleading stage is where um, the petition has been filed and you're waiting for the response, and that's the pleading stage, right? It just and the importance of that is that that pleading stage is what defines the issues in the case, whether there's going to be spousal support, or whether or not mom is going to have custody of the kids, or whether or not the parties are contesting how the assets should be divided. Following the pleading stage is discovery, and this discovery could start the day the lawsuit is filed, and it it starts with serving a request for production on the other side. And the request for production says, I want tax returns, I want credit cards, I want bank accounts, I want on and on and on. Evidence of insurance, I want investment accounts, retirement accounts, bank accounts. And by statute in Oregon law, it's ORS 107089, if you're curious, lays out minimally, if asked, what both parties need to exchange, right? So discovery is baked into um, uh, the, the divorce. You could say, I don't need any of this, I know everything, or we just need a simple divorce, we just need the court to separate us so we can go our ways. You don't have to go through discovery. Usually discovery is the most expensive part of litigation. It can be the most stressful. People don't like producing the amount of records that need to be produced. And It could be overwhelming sometimes. And then it takes time for the attorney or the office to put things together. And it's just, and then you have to do it twice. You have to do it once for you and once for the other side. So discovery it's expensive. It's frustrating. It's what pisses people off. They have to share this information. Um, but that is what discovery. And the point is though that um, both parties are working from the same starting point. They both have the same information. They both have the same knowledge about the state of the marriage, or any issue. Discovery covers any issue in any lawsuit, right? So, um, um, like just to give another type of example, if you were in a car accident and somebody rear-ended you, and you said, "Well, I hurt my neck," the other side would have a right to your um, medical record showing the neck injury, plus any history of neck injury, any medical record related to any um, neck injury that you had in the past. And if you didn't want to produce it, the courts would compel you to produce those medical records. Same thing in a divorce, right? Maybe you don't want to give up maybe you have a reason for not wanting to give up your checking account, and you don't produce it. The other side will go to court, get an order. Judge will say you have to produce it. If you don't, then there'll be a sanction, and the sanction could be attorney fees, it could be striking parts of your claim, on and on. So that's discovery. Uh, Oregon law mandates that people talk to each other. Every county is a little bit different. For example, um, there's mandatory mediation in Multnomah County, but it doesn't pertain to anything other than the kids. So other counties are different. Other counties will require you to mediate on every topic in a divorce. So you have to kind of know the rules in your county to know what's required of mandatory mediation. But generally, lawyers will try to encourage settlement negotiations. It may be in the form of a settlement letter. It may be through the suggestion that the parties go to private mediation or do some other, maybe it's through an arbitration, but they'll do something to um, get the parties talking to avoid going to trial. Following the negotiation stage is trial stage. If there's no settlement or there's only a partial settlement, that's when the case goes to trial. And I said discovery was expensive. If you get to the trial stage, you're bleeding money. It takes a lot of time, a lot of effort for an attorney to prepare for trial. You have to know all of your issues. You have to have all of your exhibits prepared. You have to have your trial memo ready. You have to know how you're going to specifically, how you're going to cross-examine witnesses, how your client is going to testify. Trial, it's expensive, stressful, time-consuming. Um, but if you can't have a success in the negotiations, then you're going to end up before a judge, and that's the trial stage. One thing about family law trials is that there are no juries. Uh, family law trials always are tried before the court alone, sitting without a jury. Sometimes in movies they'll say, "Well, we're going to take this family law case we're going to take this divorce to jury," and it's like, no, it doesn't happen. And um, uh, I'm not sure if that's the case in every state, but I think that's the case in the vast majority of states that um, there's no jury trials in family law cases, and I think that's because the states have a interstate compact for collecting child support, and part of that compact was that in order to get some uniformity, there would not be jury trials. I think, not 100% sure about that. And then the last thing that I want to cover is post-trial. And I'll come back to this a little bit, but post-trial is post-judgment, I should say, is there, even though the case is settled, somebody, wife is ordered to pay spousal support and she refuses. The husband can file a motion for contempt post-trial to bring wife before the judge again. The judge will say you have to pay your spousal support. or there'll be penalties. Usually, it's financial penalties. There could be assets that are discovered after the marriage that were not disclosed. You can go back to court and ask for those assets to be included as part of the divorce. There could also be modification. In Oregon, you cannot modify property settlements, right? Unless you appeal the case, your property settlement is what you're stuck with. Uh, um, but you might appeal uh, child support or custody or spousal support based on a change of circumstance or a new circumstance that impacts um, somebody's ability to pay, for example, or a spouse gets married or somebody retires. Those would all be grounds for going back to court to modify the judgment. Right. So I jumped ahead of myself a little bit. Uh, I did leave out in that last slide the appeals process. So if you are not happy with the judgment and you believe that the judge made a error of law, you can file an appeal with the Oregon court. If you thought litigation was expensive, try the appeals process. It is very time consuming and a very expensive addition to money that you've already spent. Uh, and the grounds for appeals are usually very, very, very narrow. And so a lot of cases uh, that do go to the appeals court are just affirmed as is. They're not reversed or remanded. They're just appealed because the courts have carved out very broad, broad um, rules that protect the judge. They don't really protect, but give the judges a huge room, a huge latitude in their decision making. So appeal, you got to do right in the trial court. You have the appeals court as a remedy if the trial court gets it wrong, but it's not always a viable remedy. So finally, let's look at some other thoughts. The whole point of taking a case to trial is that you're bureaucratizing and rationalizing conflict, right? And we're saying we can't work this out ourselves. We have a conflict. And what that does is it gives the litigants in society a rational way of making decisions. You could have a conflict. You could not want to pay somebody in a contract dispute, but you go to a lawyer says, no, you're going to lose that. Or, yes, the other side is wrong and you should take that forward. So the courts rationalize risk and decision making, right? And all of this complexity has grown up to ensure that rights are enforced and that fairness in the form of a judge's decision prevail. So the court itself is a formal way to resolve disputes, and as maybe you're getting a sense, it has evolved in complexity. And I do actually want to talk about that. I wasn't planning on it, but even in my 30 years as a lawyer, I've seen how much more complicated divorces have become. Even with 30 years of practice, I still get things wrong in terms of like making a filing or like substantively, I know the law and I'm not going to make a mistake about that. But like just sometimes, like even this stuff that we're talking about, the getting the case through the courts, you have to look at the rules and look at the local rules. And sometimes you call the court clerk or call a friend. How do you do this? Um, and so the practice of law has exponentially grown in complexity since the time that I've been a lawyer. The courts evolve. There's a situation, something didn't work the way you would expect, and then a rule gets passed. And so there are just a lot of rules, which makes it uh, harder and harder for people to do their own divorces. Um, if you and your partner during your divorce cannot come to an agreement, really your only alternative is the court. You might go to like a private mediator like myself, but ultimately your case is still gonna you still have to go through the court process to get the divorce, right? It's the court that will grant the divorce. Um, and that comes out of the historical um, situation where marriage was seen as a contract, right? And the only way you got out of a contract was by breaking it through the courts. And so the system of courts to dissolve a marriage, that's why courts dissolve marriages. Why you can't just file a form with the Secretary of State and say, okay, we're divorced, right? Like you would a business. Um, uh, it's because the contract had to be breaking the contract had to be blessed by the court, right? You had to go in with reason. I want to break this contract because. And in the old days, the court may say, no, I don't think there's sufficient cause to break the contract. Now, anybody who alleges that they can't stay married, will the court will divorce them. But that wasn't always the case. But the um, concept that the court is the way you dissolve a marriage, that's a holdover from when um, marriages were considered contracts. If you do end up in court, you need to make sure that you're finding somebody with experience in your area. You need to find somebody. I don't. I hate to say it because I started practicing the day I was admitted to practice. Uh, but you want to find somebody with 5 years, 10 years experience at a minimum. It just takes that long to absorb how things are done. If you try to do a divorce yourself, if you say, well, it's easy, we'll just file the paperwork, you can certainly do it. And I have videos on how to do it and when it's appropriate and when it's not. But make sure that you have some resources to guide you through. And the resources may be at the courthouse, but you're going to have questions. And before you get too deeply into it, you should do a little research to find out where am I going to get help when I get stuck, if you want to do it yourself. So that's my take on how you get a case through the courts. Thank you for joining me tonight. And if you have any questions, my contact information is up here. Please feel free to call. I'd be happy to hear from you. Again, Steven Leskin signing out. Thank you.